Hey guys, I'm bringing you a midweek podcast update, which I don't do regularly, but the Supreme Court decided to make a pretty monumental decision, which I wanted to get you some more information on. So I brought Josh Hammer and Matt Rinaldi, two of the smartest attorneys I know, to the table to talk about the implications of the Supreme Court ruling. So if you have seen the news and seen some of the headlines out there and the information, I think you'll really enjoy just the next 10 to 15 minutes so that you can get a little bit of an update on really what the Supreme Court decided and what the potential ramifications and implications of those decisions are. And then as conservatives, how we view that result, and then maybe how we reevaluate what we do moving forward. So anyways, hope you really enjoy the conversation.
Well, I am pleased to be joined by Josh Hammer and Matt Rinaldi, two of the smarter attorneys that I personally know in both the state of Texas and the nation as a whole. Maybe that means I need to get to know more lawyers, or
probably
means that y'all might be smart people. So we had the Supreme Court of the United States make a rather remarkable decision. And wanted to bring both of you on just to have a discussion about that. Josh, why don't you, instead of me explaining things in layman's terms, why don't you kind of tell us what the Supreme Court decided and what your take is on it? We'll go to Matt.
I'm Luke, obviously. Always a pleasure to be on with you and Matt. So, look, Title VII of the 1964 Civil Rights Act, which deals with employment law. We're talking about discrimination and making rudimentary employment law, hiring and firing decisions, prohibits discrimination on the basis of sex. Now, at the time that this was drafted in 1964, sex meant what sex means to a random person you would find on the street, which is that there were two sexes. There is man and there is woman, and you cannot discriminate on the basis of that in hiring and firing decisions. For the past 15, 20, maybe even longer than that, 30 years, the left, and especially leftist Democrats at both the federal and oftentimes state level across the country, have pushed various forms of Employment Non-Discrimination Act type provisions that would add sexual orientation and gender identity as additional protected classes under Title VII for employment law decisions. Now, for 53 years, from 1964 until 2017, when the first federal court held to the contrary, no one contested what I just said, that sex meant sex. But apparently, according to a 6-3 Supreme Court majority yesterday, led by none other than Republican nominee Neil Gorsuch himself, says that for 53 years, we were all wrong. And that sex, as it was written in 1964, actually requires private employers to not discriminate as well on the basis of sexual orientation and gender identity. Obviously, Luke, the latter, gender identity, was not even a thing. Like, it was literally not a concept at the time the statute was written. But nonetheless, we are told by the nine rubbed oracles that the word sex in 1964 nonetheless means what it, at least from my perspective, quite clearly does not mean.
Yeah. Matt?
Yeah, I mean, I think you summarized it rather well. And one of the interesting things about the opinion is it effectively did redefine sex as sexual identity and sexual preference. The way he got about that was saying that, well, you can't take into account sex. And since if somebody had a significant other who was a man and they were a woman, if they're a man, you're treating them differently. So therefore, you're considering sex in your hiring or firing decision. Same thing with if they choose to dress or identify as a woman. If it was a woman, you wouldn't say anything about it. So you're using sex to identify. That was Gorsuch's reasoning in this. But if you take that to its logical conclusion, look in the same statute in Title IX. Well, you have to ask that question when you're talking about women's sports or the number of scholarship you reserve for women. So effectively, this is mandating that I mean, taken to its logical conclusion, it's mandating that we completely abandon the protections that we put into place for women in Title IX. And in fact, I mean, take it to its logical conclusion, it has implications for speech, for religious liberty, for, obviously sex discrimination, in an act that was originally intended to prevent discrimination on the basis of sex or religion. Now Gorsuch's decision now requires discrimination on the basis of sex or religion.
I know there were some things in the opinion regarding some religious protections or what they would call like exemptions. Are either of y'all kind of familiar with some of the things that were put into the opinion about that?
Mostly punts on these issues. He mostly says that a lot of what we're talking about here is fair game for future cases. Now, he does say that RFRA remains obviously the law of the land, which it obviously is. Now, it's going to be, on the one hand, fascinating, on the other hand, also genuinely frightening and terrifying to watch how courts in the future, and by the future, I mean probably over the next year or two, start interpreting the statutory interplay between RFRA and Title VII as not as interpreted, as legislatively amended by a 6-3 court majority. But everything that we're now thinking, we're talking obviously about Christian schools, Orthodox Jewish day schools, being able to make hiring and firing decisions on the basis of what the Bible actually says. It's not an exaggeration. It is not fear-mongering to say that these decisions are going to be litigated. And Gorsuch he tries to basically say that's not before the court, but as Matt so obviously says, in legal reasoning, in legal principles, you can say to the cameras or to the masses with your pen that what's before the court is not actually before the court, but of course, in some respect, it actually is. Because when you codify a principle, those principles necessarily have consequences. And it's going to be really, 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 really scary, I think, to see what happens for religious liberty here. It's not fear-mongering. The consequences will be real.
When I was looking through the decision, my non-lawyer mind took me back to 2017. Matt knows this story, Josh, but we had this problem in Texas where there was this Privacy Act that was getting debated that had to do with men trying to go into women's locker rooms in public schools. And so they said, hey, maybe we shouldn't do that. And our Republican speaker thought it was a social issue that they wanted to avoid. So he kept the legislation killed and didn't want to talk about it. So Matt and a couple of his colleagues, including Representative Tony Tinderholt from Arlington, decided to get creative with ways of having the debate if the speaker wasn't going to let us have it. And so the Uber bill came up before the House, and it had in it non-discrimination language, right? So it said that, and this was Uber trying to pass this like statewide, regulation so that cities couldn't ban them from operating in the cities. And there was just simple NDA language in there that said, hey, Uber drivers cannot discriminate based on race, sex, blah, blah, blah. And so we added an amendment into that NDA language. Tony Tinderholt offered one that said sex is defined as the biological state of one's being, male or female. And it got all sorts of controversy. They didn't know what to do with it. They didn't know who it was discriminating against, first and foremost. So there's this big debate. Are you discriminating against somebody or are you not? And Tinderholt just said, no, I'm just stating sex means this, right? That's all. And so it passed. Then Uber decided they didn't know what it meant either. So they actually publicly opposed their own bill and then asked, for the language to get taken out. It created this whole controversy. But what I found interesting was we were doing it as kind of a publicity stunt and also a way to say, hey, let's have the debate on gender fluidity now, whether you'll let us or not. But I feel like Gorsuch is basically saying, no, you literally need to put that in every statute, that sex means exactly this, because otherwise you let me, Neil Gorsuch, decide what sex means, however I feel like it means 50 years after it's passed into law.
Well, yeah, I mean, I wasn't doing it as a publicity stunt. I was doing it literally because I could foresee this decision coming down in the next couple of years.
Yep.
I didn't know it would come down with a conservative court.
Yeah.
And you saw even the GOP was very uncomfortable with it. And I think that brings us to a bigger context is, what after this decision, with the court essentially becoming a legislative body and changing the meaning of this very important statute, what's the purpose of the GOP? What are we doing? I think we seriously need to re-examine our purpose and our tactics, right? I mean, we're in a war right now. When you look at what's happening, we have a metaphorical and actual, in some instances, insurrection that's being encouraged and supported by one of our two major political parties. We have Democrats that are calling out their colleagues as racist and sicking the mob on them. Meanwhile, our Republicans are sharing social media messages, palling around with Democrats and talking about sports. I mean, you have Christians under attack. Our cities are burning. I don't know if there's going to be an America that's going to exist for my son, but whoop-de-doo, my legislator made a new friend. I mean, we're in a war. These people ask to be on the front lines. Grow a pair and do your job.
Josh, what do you think about a lot of the federal, reactions to Gorsuch's decision? Because I think the Republican Party is in kind of a tough place. What do they say when, the guy they lauded as their option, and the Supreme Court has been such a big issue for Republicans each election year? What kind of position are they in?
I tweeted yesterday morning, shortly after the decision came down, what is the purpose of the Republican Party? I think I got like 8,000 or 9,000 likes, or something like that. And I mean, I think a lot of conservatives seem to also be questioning what is the purpose of the Republican Party. These are fair questions. I mean, look, I was told that even if the Republican Party would not touch cultural issues, if they would not touch immigration, transgenderism, any of like the wedge cultural issues, I was informed, Luke, by the powers that be, that the GOP was at least good for three things: judges, cutting taxes, and like maybe bombing terrorists overseas. The first plank, arguably the single most important plank, by the way, for the reason that Trump is president in the first place. If you go back to the 2016 exit polling, a plurality of Trump issues selected the Supreme Court, and specifically at the time, filling Antonin Scalia's seat as the number one issue that they voted for then candidate Trump. So if we throw that out the window, if the Republican Party cannot get judges right, it's really not clear what exactly the purpose is. And just to contextualize this, I know this it's not going to be news, obviously, to either of you or to the very informed viewers in the audience, but the Republican Party, this is not exactly a new phenomenon where the GOP has had a problem with picking faithful conservative judges. This is a problem going back literally 50, 60, maybe even 70 years, like the Eisenhower administration, John Paul Stevens, David Souter, Harry Blackmun. I mean, John Roberts, obviously, Anthony Kennedy. These are all Republican nominees. Yeah, exactly. These are all Republican nominees. Many of our own worst enemies on the high court were nominated by the GOP. So what is the purpose of the Republican Party? What does the so-called conservative legal movement and the Federal Society even like purport to stand for anymore? These are all totally fair questions. I don't have all the answers, obviously, but we need to start asking these questions and reforming institutions accordingly.
Matt, I feel like years ago, even a couple of years ago, when different conservative lawmakers would say, hey, I want to pass these policies in opposition to precedents set by the Supreme Court, it was still there was a lot of pushback you got within the GOP. Do you think even that is going to see a shift potentially within the lawmaking conversations?
I hope so. I mean, we need new strategies. I remember back when I was a youngin', I was a caller on the Rush Limbaugh show, and I had talked about a different approach to judicial conservatism because this wasn't going to work long term. And I remember he didn't even understand. I mean, even a strong conservative like him didn't understand it, never mind other individuals in the movement. We need to be talking about a different approach, I think, to how we choose our judges and their philosophy. I mean, we could talk about tactics in terms of whether or not we need the president, and I think we do, to set a precedent by selectively defying a federal court decision in order to take back more power to the executive branch and legislative branch and executive branch. I do think we need to re-examine what it means to be a judicial conservative. Simply saying judicial restraint isn't going to cut it anymore. We need to elect men and women who will disregard bad precedent, interpret the Constitution the way it was meant to be interpreted, and have our guys ram it down their throats just like they do to us. We have two people on the court right now, Alito and Justice Thomas, who are willing to do that, and we need more men like that.
Josh, any other final thoughts?
Every single word that Matt just said, I'm in wholehearted agreement there. It's so crazy. There literally are two reliable justices on the court. I mean, like, the left freaks out this big, bad conservative court is going to overturn Roe versus Wade. I mean, for God's sake, I mean, we have people defecting on all the major issues. I mean, like, the DACA case is going to come out soon. I mean, hard to have high hopes for that one at this point, right? But I mean, look, the question is what comes next. You know, Luke, I'm not sure when this podcast will be released, but we're recording this on Tuesday. Josh Hawley had a fascinating floor speech just about 2 hours ago, maybe a little under 2 hours ago, where he declared the end of the conservative legal movement as we know it on the Senate floor. Hawley himself went to Yale Law School. He was like president of his FedSoc chapter there. He clerked for the Chief Justice of the Supreme Court. So when he says something like that, it actually carries sway. It has impact. And what theoretically and jurisprudentially we stand for is going to be the focus of a lot of kind of nerdy kind of lawyer inside baseball type conversations. I mean, Professor Adrian Vermeule of Harvard made a lot of waves for his post-originalism, common good constitutionalism essay in late March, early April. I had a response last May called Common Good Originalism that was trying to paint something of a middle ground path forward. But all of these competing theories of jurisprudence, I think, are basically fair game, because if, as Josh Hawley said in his floor speech, if textualism gets you to what Neil Gorsuch did, even and look, that's not good textualism, but if a Republican nominee is doing what he thinks is good textualism and it gets to that result, then textualism itself has an issue.
Matt, any other final thoughts?
No, I agree. We need to re-examine what it means to be a judicial conservative. We need, in the broader fight, a greater focus on public education, which reps have been unwilling to even touch, universities, our culture. We need to look at it in a much broader perspective, because we're really building our movement from the ground up, and whether that be a different approach to thought, like Josh had just mentioned. I particularly, Randy Barnett was my common law professor, so I particularly like his approach to textualism, and an original meaning approach at the time, which wouldn't have arrived at this decision, of course. But there are a lot of different competing philosophies, but the simple conservative judicial philosophy of a sort of vague textualism / originalism when it suits the justices, and outcome-based judging just isn't going to do it anymore. So we need a change.
Well, guys, thank you both. Don't want to keep you too much longer, but I'm very appreciative of you giving me a little bit of your time, and we'll be releasing this here pretty soon. It's a good conversation to have. I think Republicans and conservatives can take a look at what we're being presented as the outcomes of our efforts and say, hey, we should take a different approach. And the problem is that many of our leaders don't seem to reevaluate when the outcomes end up very different than they were before. They just often say, well, let's find a new way of saying that, and let's cover up these mistakes and continue on with the same old. So that's why I'm appreciative of Senator Hawley saying what he said, and let's hope that a couple others are willing to join that chorus and take a little bit of a different approach. Thank you both for joining and giving some of your insights.
Thank you. Appreciate it.
Thank you so much for watching this video through in its entirety. If you're somebody who's been following on with the conversations and the commentary that we've been producing here, we're going to ask you to do a couple quick things. Go to lukemacias.com. You can give us your email and sign up. We will email you new content, commentary, conversations as we produce it. Also, you can, if you're on Facebook or YouTube, you can like our page, follow our page, or subscribe to our YouTube channel. This will just continue to ensure that when we produce content, it gets to you more easily. Thank you so much for continuing to support the conversations we're producing. God bless you. God bless Texas.